Good evening, Professor Denise McVea here, and this is my personal story of defamation. First, let me tell you a little bit about myself. I'm an independent investigative journalist and a nonprofit publisher. I grew up in San Antonio, Texas, and earned a journalism degree from Texas Women's University in 1990. I worked in corporate newspapers for a while, but became frustrated with the way in which mainstream media covered or failed to cover issues affecting my communities. I eventually moved to Mexico, where I lived for about 10 years before moving back to San Antonio in 2009. Moving back to the U.S., I was not surprised to learn that the American newspaper was rapidly going extinct. I had predicted that back in the 1990s. Newspapers, by their failure to adequately cover the concerns and experiences of everyday Americans, had made themselves irrelevant in the American social fabric. I believed that a new news paradigm was needed. In 2003, I founded the RS Project, the 501c3 nonprofit organization whose mission it is to help poor and otherwise marginalized communities gain access to key rights and development information. At the RS Project, we believe that the right information can change the world. The RS Project seeks to redefine how the news is told from the perspective of the historically ignored community. To that aim, the RS Project possessed a long-abandoned, blighted property on the east side and began building an information center for the beleaguered community here where I grew up and where I live today. Almost immediately, residents began to share stories about organized illegal schemes to transfer real property away from struggling poor families into to outside investors who were not in the chain of title. The victims of this brazen theft had nowhere to turn in Bexar County, not the courts, the police, the press, or city or county governments. It was, I soon understood, a widespread criminal conspiracy and cover-up targeting the city's most vulnerable residents. I began documenting those complaints. Soon, the RS Project would be summarily evicted from the Information Center on the basis of what a court-certified forensic document examiner determined were forged and fraudulent quitclaim deeds. I documented that scheme, too. That illegal transfer was facilitated by several lawyers, several notaries, several judges, a former county commissioner, and members of the San Antonio Police Department. I was soon the target of unrelenting official oppression. In fact, I became the first person in the history of San Antonio to be arrested and jailed for allegedly having a garage sale without a permit. A local federal judge ruled that the police were justified in arresting and jailing me for a misdemeanor garage sale permit violation that does not exist in the Texas Penal Code. In fact, the cronyism and corruption is so endemic in San Antonio that when the U.S. Attorney's Office prosecuted a local judge for corruption, it felt compelled to prosecute the case in New Mexico. But what does all of this have to do with the tort of defamation? What is defamation anyway? Defamation is an intentional tort. According to legal scholar Roger Schechter, a plaintiff in a defamation lawsuit must prove four things. One, that the defendant made a false and defamatory statement that specifically identified the plaintiff. Two, that the defendant published that statement. Three, that the defendant acted with fault, meaning that he made the statement lacking a good faith belief that it was true. And four, that there are presumed or special damages as a result. A defamed plaintiff can recover presumed damages for injury to his or her reputation and or emotional and mental distress without having to show proof. Special damages, on the other hand, refer to specific financial and pecuniary harm and must be proven and quantifiable. Under defamation law, someone can be defamed in two ways: through slander which refers to defamation that is spoken, and libel, that refers to defamation that is written. Defamation law has serious implications for journalists and media outlets. All journalism students are required to take media law courses that tackle the subject of defamation in depth, and media outlets provide additional periodic training for journalists they employ. Perhaps the most consulted defamation case by journalists is the 1964 Supreme Court case of New York Times versus Sullivan. It codified the standard that a publication is libelous per se if the words, quote, tend to injure a person in his reputation, or to bring him in public contempt, or injured him by imputing misconduct to him in his office, or want of official integrity, or want of fidelity to the public trust, end quote. In other words, spreading damaging falsehoods about a person is defamation, and it is actionable. Libel per se, by the way, are words that directly defame a person, as opposed to libel per quad, which can be described as indirect or implied libel. In Times versus Sullivan, the Supreme Court established that a public official could not recover damages for a defamatory falsehood relating to his official conduct unless he proved that the statement was made with actual malice. Actual malice occurs when a false statement is made with knowledge of its falsity or with a reckless disregard for the truth. This is an important free speech protection for journalists whose jobs it is to hold public officials accountable to the public. Essentially, it makes it harder for plaintiffs to prove defamation if they are public figures. As a journalist and historian, I have had a lot of experience with defamation lawsuits. I was once sued by a Dallas landlord for defamation after writing a story that referred to him as a slumlord. I won that case, but then a few years later, I sued a historian who denigrated my research on about a historical person of color. I lost that case. However, the court did not consider actual malice in either of those cases because in both those cases, the plaintiffs failed to carry the burden of proving the most important element, that the statements were false and defamatory. In the landlord case, the court found that the complained of statement was substantially true. And in the historian case, the court found that the complained of statement was a matter of opinion. Actual malice is considered by many to be hard to prove, making defamation cases a perceived uphill battle for plaintiffs who are public figures. However, this does not give defendants a free pass, as two very recent, very sensational defamation lawsuits showed. They are Dominion Voting Systems versus Fox News and Depp versus Heard. In both cases, the plaintiffs, who were public figures, prevailed over the defendants. Fox News settled Dominion Voting Systems for a whopping $800 million to avoid going to trial after pretrial evidence clearly showed a reckless disregard for the truth when Fox repeatedly published accusations that Dominion engaged in fraudulent activity that Fox claimed negatively affected the outcome of the 2020 presidential election, despite ample evidence to the contrary. And a California jury found that actor Amber Heard defamed her ex-husband, Johnny Depp, by insinuating in an op-ed for Vanity Fair that Depp had subjected her to domestic violence. Using the California jury verdict form as guide, the Fairfax County jury found that Heard published a false statement about Depp that had defamatory implications, that the defamatory statement was designed and intended by Heard, and that the statement conveyed a defamatory implication to someone other than Johnny Depp. Having answered yes to all of the elements required in the jury verdict form, the jury found Heard also acted with actual malice when she published the false and defamatory statements against her famous ex-husband. I watched these cases with interest because I found myself once again contemplating a defamation suit, this time against the San Antonio Police Department. Because the poor residents of blighted areas are perceived to be powerless and ignorant by the people robbing them, the co-conspirators in San Antonio's illegal property theft scheme, title transfer schemes, took hardly any care at all in covering their tracks. When it became clear that one of those poor residents was a trained investigative journalist gathering evidence of the crimes, I became the target of sustained abuse and official oppression, including countless incidents of vandalism and theft, assaults, gang stalking, false arrests, malicious prosecution, cyber attacks, invasion of privacy, network intrusion, and more. Despite ample evidence of these crimes and numerous pleas for help from the police took no action. In 2020, I made an Open Records Act request for all of the dozens of police reports I had made regarding the attacks on me, and found that 99.9% of them were false. More importantly, many of those reports described me as a quote-unquote psych. And in other words, Eastside police officers willfully withheld evidence that I'd given them, and hid the identities of criminal actors in my community while taking every opportunity to attack my credibility. It soon became clear that the constant attacks on me and my assets were a depraved effort to traumatize me to the point where my general demeanor would eventually match the false and defamatory descriptions flooding San Antonio Police Department police reports. By the glory and grace of God, I survived all of that. Others were not so lucky. In 2018, San Antonio Police Department officers shot and killed San Antonian Kirsten Klopp in her own home after she called them for help. Klopp had made identical claims of harassment to the claims I made repeatedly to the police. I do feel blessed to be alive, and I think about Kirsten all the time. God rest her soul. I believe I have a prima facie case of defamation per se against the San Antonio Police Department. First, SAPD falsely claimed that I was mentally ill, and then published the false and defamatory claim to a police incident report database consulted by thousands of law enforcement officers. Certainly, police characterization of the complainant as psych carries a defamatory implication given the amount of evidence that were supporting my complaints. The police reports clearly identified me. They contain my name, my address, my phone number, my date of birth, and my general physical description. And once published, the false statements were then used as a rationale to not investigate the reports of organized criminal activity preying on our community, proving mens rea behind the defamation and leaving me vulnerable to repeated criminal attacks that, unhampered by legal and constitutional protections, increased in frequency and severity. In other words, actual malice is present. It is unclear whether I would be considered a limited public figure given the years of forced isolation I endured. But what is clear is that we are at a crossroads in America where it seems every democratic principle and institution are under sustained assault. The fight continues, and there is much at stake. I thank God every day for giving me the opportunity to seek justice, and I remain committed to my purpose. I find resolve in the verse from Ephesians 6:10. It reads, "Finally, be strong in the Lord and in the strength of his might. Put on the whole armor of God, that you may be able to stand against the schemes of the devil. For we do not wrestle against flesh and blood, but against the rulers, against the authorities, against the cosmic powers over this present darkness, against the spiritual forces of evil in the heavenly places. Therefore, take up the whole armor of God, that you may be able to withstand in the evil day, and having done all, stand firm." Amen.